afternoon, everyone. Thank you for joining us today in our online talk. We will begin shortly at 3 p.m. For those of you who are here early today, thank you for waiting patiently with us. While you're waiting, we would like to share with you a short video of our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today in our online talk entitled Managing Poor Performance. My name is Jasmine Wong, and I'm an associate with Wong and Associates. I'll be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Wong and Associates is a mid-sized law firm that was founded in 1985 by Datuk Wong. Our team today comprises of 22 lawyers and a support team of 19 people. Datuk Ma is now a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment department, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by the talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which have also been broadcasted live. But with the COVID-19 Movement Control Order, or rather MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is the 30th talk in our MWKA online talk series. You can visit our website at mawenkwai.com for more information, to read our articles, or to sign up for more upcoming talks. Now, before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. And now let me introduce both of our speakers for today. Firstly, Janessa Corp, our associate in the Dispute Resolution, Employment, and Individuals and Families Department. Janessa holds a Bachelor of Laws from the University of Liverpool, and she was admitted to the Malaysian Bar in 2017. She focuses on the advisory and litigation matters relating to employment and industry relations. Janessa also practices general litigation. Next, our speaker is Wong Su-Ann. She is our associate in the Dispute Resolution, Employment, and Individuals and Families departments too. Su-Ann holds a Bachelor of Laws from the University of London and was admitted to the Malaysian Bar in 2018. Su-Ann's practice area includes employment law, debt recovery, probate and administration of estate, construction, and family law. Our speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, don't forget to post them up on Slido, and our speakers will address them later. You should have received a link to Slido during the registration, but I will leave this slide for a while so you can scan the QR code before we move on. Or you can also go to the Slido's webpage and key in the code 18817. Su-Ann, our first speaker, will start things off by giving an overview on poor performance and how we can overcome poor performance with the Performance Improvement Plan, of PIP. She will also touch on whether poor performance will amount to misconduct. Later on, our second speaker, Janessa, will provide some guidelines on how to manage poor performance. She will also address the issue of termination due to poor performance. With that said, I shall now pass the floor to Su-Ann. Over to you, Su-Ann.
Hi everyone. Thanks, Jasmine, for the introduction. Let's start today's talk. First, I will talk on the point of what's the overview of poor performance. Okay, what amounts to poor performance? So it's a generally acceptable ground for dismissal, but what amounts to poor performance is a question of fact. What that means is that it's a very case-to-case basis. For example, if you said that someone is performing poorly because he didn't fulfill a certain sales target, was that sales target known to that person? Was that failure a one-off time? So there are a lot of circumstances and there's a lot of questions that we will need to consider before considering whether that specific situation amounts to a poor performance. But generally speaking, examples of poor performance will include the inability to meet a required work standard, or low productivity, or a failure to achieve targets set by an employer, or you can't work with your teammates. Okay, in this case of IE Project, Sindram Bahat and Tan Lee Singh, so the industrial court said that an employer should be very slow to dismiss on the grounds of poor performance. If you are to do that, you have to first tell your employees the respect that you are failing to do his work properly, warning the possibility of a dismissal, and then giving the opportunity to improve. Because this is linked to what we call the burden of proof, which in cases of unfair dismissal, the burden is on the employee. The burden is on the employer to show that on a balance of probability that employee was terminated with just cause and excuse. So you need to show on a balance of probability that poor performance, that person's conduct, that you sufficiently terminated that fellow because of the poor performance conduct and there was reason for it. In this case of Erica Construction Berhad, the company gave two reasons for dismissing this employee. One was on poor performance and the other one was his frequent taking of unjustified medical leave. The industrial court stated that in order to justify dismissing someone on poor performance, you will first have to warn that person of it, provide the person with sufficient opportunity, and after you completed both of the above, the employee failed to improve his performance. That's when you will be able to say that you have dismissed someone with just cause and excuse. But how can an employer gauge what's the person's performance and whatnot. There has to be a tool for it. And in this case, we have something called a performance improvement plan. Okay. So a performance improvement plan acts as a warning for unsatisfactory performance and a guideline to train an employee and to set their expected improvement on record. So what it means is that this is like a tool for the employer and the employee themselves to see what's that employee's performance, why was it poor in the first place, what actions can be done, and the time period for the person to improve. So usually the performance improvement plan will include stuff like the employee's unsatisfactory performance. It will be specific, and then the employer will give actions on what is required of the employer to improve, what standard is expected of the employee, and most importantly, there will be a certain timeline for that employee to improve, or for there to be a review with the employer, so that you know whether that employee did improve or not. In this case of Noren Rezian Osman Saleh, the industrial court in this case kind of like gave a definition of what is a PIP. So the court said that PIP is a method or a process that is initiated by a company in situations where an employee struggles to perform his job to the satisfaction of the company. And then the company is expected to provide the necessary assistance and tools to help the employee improve, because you can't just say that, look, you're not performing to a certain standard and then not give the employee the necessary help. You can't just leave the employee to go on his own frolic or whatnot. You have to give the sufficient help because the burden really is on the employer. Okay, and most importantly, PIP should not be made a tool designed to prepare an employee for their exit from the company. So when a company starts doing the PIP, they shouldn't do it with the intention of dismissing the employee. It should be with the intention of to give the employee time to let the employee know that you have this kind of performance review, you have this poor performance and this issue, but we're willing to give you this help. And you can't just let it be a tool to say, oh, I'm putting you on the tool just so that I can dismiss you. That would be very unfair to the employee. In this case of Mohammed Rizwan Al-Qasim, this is a case where the employee was placed on a PIP for about 5 months before being terminated. So during this 5 months, this entire PIP, he was given an objective and target of what was his monthly sales that he had to achieve. He was given, the company conducted 3 performance review sessions with the employee, informing of what was his performance was unsatisfactory, what areas to improve, and then there was even coaching sessions. So the company provided the employee with a coaching session to say what needed to be done and how to achieve those targets. This evidence were all not challenged by the employee in court. So the court held that there was the employee was dismissed with just cause and excuse, because during that 5 months of PIP, he had failed to show improvement, despite the help that he was given, despite the warning that he was given. More importantly, if you can look at the clause 56 there, it says that the claimant knew or ought to have known the consequence of not achieving the target under the PIP. Despite being aware of the consequences, which included a potential dismissal from his employment, he had failed to take proactive steps to rectify his shortcoming. So for the court, it was sufficient to show that during this PIP, the employer had given the employee various opportunities to improve themselves, but the employee didn't, and then the dismissal of the employee was with cause and excuse. But for courts, what it means to improve to the satisfaction of the employee is that the judge really gave the employers like the judge give the employer to decide what it means to their satisfaction, as long as it was done bona fide. It wasn't done with any ill intention. It was done fairly. But what happens if an employer refuses to participate in the PIP? Well, in this case of R. Tiaga Raja, this employee was terminated due to his insubordination for his failure to follow his company's instruction to be placed on PIP. The reason why this employee didn't want to be placed on a PIP was because he said that he had no work performance issue and hence he should not have been placed on PIP. But the court held that the employee was duty bound to comply with the company's instruction and cannot choose to defy the instructions on the ground that he was disputing the result. The employee must obey the lawful instruction of his superiors, even if the employer disagrees with this instruction. So in this case, the court said that you should have still been placed on PIP. The other fact that the judge did consider was that in this person's company, there was a grievance policy. So if you felt that you were unfairly placed in the PIP, you shouldn't have refused the PIP. You should have gone through the proper procedure following that grievance policy and raise your dissatisfaction there. So that's why in this case, the court held that the employee should have followed should have gone under PIP, and by not going under PIP, he was being insubordination. As opposed to this other case, in this case of Michael Brian Davis against Microsoft. So here again, the employer refused to be placed on the PIP because here the employer was of the view that the PIP was a sham. The industrial court agreed with the employer, same like the first case, saying that the employee should have gone through the PIP. But on review in the High Court said that the PIP was a sham, and the industrial court should have considered that the employer actually prepared 2 letters of resignation for the employee to sign before placing the employee on the PIP program. So what it means is that the PIP was not done fairly. It was done with ill intention. Hence why the court accepted this submission that the PIP was a sham. Okay, moving on to my next point. Does poor performance amount to misconduct? In this case of Eritam Erakasamy, it says that a workman who does not show enough care or enthusiasm in his work, but nonetheless plods on with the work, does not necessarily commit misconduct. So poor performance does not equate to misconduct. It's not misconduct per se. And it's only in very rare situations where a poor performance will amount to a misconduct on its own. See, in the Court of Appeal case of Tan Po Tian against Industrial Court of Malaysia, it says here that it must be strictly observed that industrial law jurisprudence does not permit all form of unsatisfactory conduct or poor performance or negligence to be labeled as misconduct. There are certain acts of conduct amounting to misconduct, but it's not the same thing. You can't equate poor performance as misconduct. In this case of Kim Elsdare Louis Sargent, so the employee here was dismissed on the ground of poor performance by the company. The court held that there was no evidence to show that there was any warning, oral or written, had been given to the employee in respect to his performance. But there were, however, 4 letters of complaint against the employee. The judge decided that those letters of complaints were more inclined to misconduct and rather than poor performance. For the judge went on clearly to say that there is a distinction between poor performance and misconduct. And depending on this allegation, there are certain procedures to follow. If there's an allegation of misconduct, you're required to show cause letter which lead to finding of guilt. Whereas if there is a poor performance issue, you're supposed to give warning or discussion on the alleged poor performance and then give the employee sufficient time to improve. Dismissal should only be an option if the employee failed to improve. So we shouldn't mix up misconduct and poor performance together. In this case of Muhammad Hilmi, so here again, the employer was terminated due to his poor performance because of his failure to meet sales target. In this case, the court held that poor performance, the company has proven on a balance of probability that the claimant is guilty of misconduct in the form of culpable incompetency or inefficiency. What it means is that when the culpable incompetency and inefficiency are misconduct and can be causes of dismissal. So the poor performance here had culminated into a form of misconduct in the sense that you have done your work so poorly to the point where it had led to a misconduct. For example, if you're an accountant and then you're supposed to prepare certain reports, but because your reports are so bad, it had gone to the point where it's a negligent. That would mean that it's a misconduct. Yep. So we shouldn't, at the end of the day, we should be clear that while there are circumstances, there are very few circumstances to show that poor performance equals to misconduct. It can be done, but you would have to prove it beyond a balance of probability that such circumstances did exist in court. And now I will pass the floor to Janessa.
Hi everyone, I'm Janessa and I'll be taking over from here to continue the discussion on issues pertaining to poor performance. So as introduced by Jasmine earlier, my top points will be primarily on two key issues. Number one, how to manage poor performance. And number two, can employees be terminated on the basis of poor performance? And if the answer is yes, what are the proper procedures to be carried out? So to kickstart, let's look at the methods available in managing poor performance. Number one would be warning. Warning is very crucial in many instances, be it poor performance or misconduct. So when an employee is performing badly, it is very important for the company to give them the necessary heads up or warning. There are two ways to go about it. Number one, verbal warning, or number two, warning in writing. It is, of course, always very advisable to put things into writing, as that would ensure that the company has the necessary documentary evidence. So for instance, if an employee lodges a complaint at the Industrial Relations Department on the basis of unfair dismissal, the company will have the necessary documents to support the company's position. The key word, as you can see here in my slide, is sufficient warning. Some of you may ask, what is sufficient warning or what amounts to sufficient warning? This is rather subjective and it varies on a case-by-case basis. A classic example would be if an employee fails to meet the necessary sales target for 5 consecutive months, and the company only verbally informed him like, hey, you did not meet the target again. Subsequent to that, the employee continues to perform poorly, but the company did not follow up or did not give any further warning or instructions. Would the earlier command made to the employee be deemed sufficient notice? Probably not. In fact, it may also amount to condonation. Next would be opportunity to improve. So assuming the company has given sufficient warnings to the employee and reasonable follow-ups in between were made, the next element to take into consideration is whether the employee is accorded sufficient time and opportunity to improve on his performance. Again, you may ask what amounts to sufficient time and opportunity. This is also very subjective, but I would say that it depends on a few factors. Number one would be the nature of the employee's job. Is the employee's job very straightforward or is it rather complicated? The next thing to take into account is the seniority of the employee. Has the employee been in this field or with the company for a long period of time, or is the employee a fresh graduate that has recently joined the company? Another thing to look at is training. Did the company provide the employee with the necessary training? Or did the company assign a mentor or a direct superior to guide this particular employee? These are the factors that the company should keep in mind at all times when the company is managing issues pertaining to poor performance of an employee. So in addition to the few factors that I mentioned a while ago, I've also briefly listed down other key elements to be observed. Discussions, transparency, understanding the employee, finding out what is lacking or what is required by the employee in carrying out his or her functions. Coming up with an action plan, have progressive assessments. The company should also get updates or touch base with the employee from time to time. All these elements are important in managing an employee's poor performance. It is important for the company to have transparent discussions with the employee to understand the underlying issue. It is also vital to find out what is the reason behind the employee's poor performance. Through these discussions, the company may discover that the employee is, for example, merely overwhelmed by the workload, or in some instances, the employee simply needs more support from other colleagues. If the problem faced by the employee is due to insufficient support, then perhaps an action plan would be necessary. An action plan may include a redelegation of work, expanding the team, or even reshuffling the team members in order to achieve a balanced internal system that will be more productive for the company. If, however, the employee is simply lazy, or in the company's opinion, the employee is incompetent, the company may also consider sending the employee for counseling or place the employee under a PIP. After all these are identified or explored, and if a warning has been given to the employee, it is also important for the company to set an achievable goal for the employee. When the company sets a goal, always remember to set a timeline as well. But of course, the goal and the timeline set by the company has to be reasonable. So, since dismissing the employee summarily without warning, etc., is not an option, I believe the company is also concerned about what the company can do in the best interest of the company, especially during the process of handling the employee's poor performance. So these are a few options that is available for the company. Number one will be extension of probationary period. Of course, this is only applicable to non-confirmed employees. Number two, the company can also consider temporary freezing of increment. I believe majority, if not all employment contracts, contain a clause on increment of salary. And it is also a standard practice that such discretion would lie with the company. It would not make sense for the company to give a pay raise if an employee is said to be performing poorly. As such, the particular employee's increment should be halted until such time the company is of the view that the performance has been improved. This would apply to bonus and promotion as well. Of course, if the company has informed the employee that his or her performance is unsatisfactory, the company should not then proceed with any internal acknowledgements or rewards for target achievers, etc. Let me give you an example of the situation that we usually come across in the industrial court. So an employee is performing badly. The company gave numerous warnings and training to the employee. The company even placed the employee under a PIP. After all those, the employee still fails to meet the necessary targets set by the company. No surprise, the company decides to terminate the employee, but with notice. Throughout this entire process that I just mentioned, the company actually carried out the entire process fairly. Unfortunately, there is an email to the employee which was sent by her superior, for example. And the email states, you did a great job. We managed to close the deal because of your help. Thank you very much. Okay, so this email was sent to the employee. the employee would go to court and say that the termination was carried out in bad faith. Why? Because as far as the employee is concerned, his direct superior is happy with his performance, and therefore the company should not have terminated his employment. With that being said, let's move on to my next slide. So, these are a few tips for companies or employers. It is advisable to state in the job description what is expected of the employee or what are the targets to be achieved by the employee. Always ensure that all documents in regards to the employee's performance are properly filed and well kept. Documents would include things like a formal letter, notices, memos, or even meeting minutes. Email correspondence and text messages are valid as well in the industrial court. When the company provides training to employees, do set the necessary goal, be it short, medium, or long-term goals. Have annual appraisals or performance assessments to keep the employees informed and updated. I think it is always important to remember that employees would want to know how they are performing and what areas can be improved on as well. So what about probationers? These are a few frequently asked questions that we often get from our clients. For example, is it mandatory for the company to confirm a probationer? Can the company terminate the probationer summarily purely because of poor performance? Is a probationer accorded the same rights as a confirmed employee? Must a probationer be placed under PIP, bearing in mind that the employee is still under a probationary period? So in this case of Siddharth Berhat, a probationer was terminated during his probationary period, and no surprise, he lodged a complaint at the Industrial Relations Department, and his case was subsequently referred to the industrial court. Just a brief background of this case. The employee commenced employment as a senior manager, and his initial probationary period was for 6 months. It was, however, subsequently extended to 3 months. At the end of the 3 months, he was terminated with immediate effect. Upon hearing the merits of the case, the court held that the termination was done by the company fairly because the company had the necessary evidence to show that the employee's performance was appraised. The company also had documentary evidence to show that the employee was duly notified. I think the point that is worth highlighting in this case is that the employee also acknowledged receipt of the letter or notice from the company pertaining to his poor performance and extension of probationary period. So again, proper documentation is very important. Similarly, in the case of Kevin James against Aeon, the employee was on probationary period for 6 months. And during the probationary period, his attitude and work performance were found to be unsatisfactory and unsuitable for the company's culture. The more serious issue for this case is the fact that the employee had disclosed certain confidential information to an outsider without the consent of the company. The company gave him opportunities to rectify his errors, to improve on his performance, and the company also gave the employee several verbal and written warnings, but unfortunately to no avail. The court in this case was of the view that there were sufficient communications in regards to his shortcomings. The company had tried its level best to guide and assist the employee in his work performance. However, despite the company's efforts, the employee's performance nevertheless fell below the expected standard. Despite the warning letters and performance reviews, the employee still refused to improve himself. As such, the company exercised the company's prerogative to terminate his employment. The court was of the view that the termination was with just cause and excuse. Noteworthy point in this case is that the court also acknowledged that the yardstick to be used to gauge an employee's performance is best left to the company's prerogative. And for this case, there was no necessity for further warnings whatsoever, bearing in mind that the employee was still under probation. So these are a few points to take note of. And these points are particularly for probationers. Probationers are, as a matter of fact, to a great extent, accorded the same rights as confirmed employees. While the employer has the right to extend the probationary period, the employer cannot terminate the probationer's employment without just cause and excuse. The employer will still have to give the necessary warning, give sufficient opportunity to improve, and have valid grounds to terminate the probationer. A probationer and a confirmed employee ought to be treated equally and fairly. I guess the only common difference between a probationer and a confirmed employee is the employment benefits that is usually given by the employer. So what about senior employees? These are the questions regarding senior employees that we usually get from our clients. Can the employer place an implied standard on a senior employee? For instance, can there be a silent expectation placed on a senior employee? Can a senior employee refuse to undergo a PIP? Or can a senior employee inform the company that he or she is experienced enough to handle the comments or feedback from the company to them? As such, a PIP is not required. Can the employer place a higher expectation on the senior employees as compared to the junior employees? Another question that we usually get is, can the employer terminate the senior employee without a PIP? As a matter of fact, there are also instances where our client would ask whether or not a company can hire a new employee for a senior position but be placed under a probationary period. Let's take a look at the case of Danco Industrial Corporation Berhad. A few questions arose in this case, particularly two: whether warnings must be given to employees who are holding senior position, whether such senior employees should know how to work effectively without warning from the company. The court in this case interestingly highlighted a few things. Number one, being in senior management, the employee ought to know what is to be done and how to prioritize her work. An employee who is placed under a probationary period is technically on trial to prove to the company that he or she is fit for the post. The court also held that the employee was still on probation, and because of the serious shortcomings committed by her, some or all considered very material to the company, the court agreed that the termination of the employee was with just cause and excuse. As for this case of Martin Lawrence Berg, the court held that the company's decision to terminate the employee was without just cause and excuse. As you can see in my slide here, although the employee had been slow at his work, he nevertheless managed to produce new products during his employment with the company. And evidently, the company delayed in acting on or giving notice to the employee regarding the employee's purported poor performance. This case will be a great reminder of the key issues or the key points that I pointed out earlier at the early stage of my session. Proper documentation, sufficient notice, sufficient time, touching base with the employee from time to time, or progressive updates from the employee. All this would be very helpful for the company, especially if the matter goes to the industrial court. For this subtopic on senior employees, these are a few key issues to remember. Employers are expected to act promptly in the event an employee is found to be performing unsatisfactorily. Delay in notifying or warning the employee may amount to condonation of his or her poor performance. Progressive reviews and annual appraisals are highly advisable. The goals or targets set by the employer ought to be reasonable based on the position held by the employee. So, what happens if the company has carried out all the necessary steps? Or what if proper procedure has been observed by the company, but the employee's performance remains unsatisfactory? Can the company now decide to terminate the employee? Flowing from all the explanation and case studies earlier, the quick answer to this question would be yes. So let's take a look at a few more decided cases which held that termination due to poor performance is valid. Thereafter, we will move on to the Q&A session. The first example I would like to share with you is the case of Badrul Hisham Ramli. Similar to the previous case examples, the employee in this case was also warned about his poor performance. He was also given sufficient opportunity to improve, but nevertheless failed to do so. The employee was initially placed under a PIP for 3 months and then an extension of another 3 months. While the employee managed to improve on one particular area, there were many other areas that he failed to improve on. With all the documents available and based on the facts of the case, the court held that the employee was rightfully terminated on the basis of poor performance. In this case of Siti Hajar Jamaluddin, the court held that the company rightfully terminated the employee due to poor performance as well. In this case, the court acknowledged the fact that the company has exhausted all avenues in dealing with the employee's poor performance before coming to a conclusion that a termination was necessary. The court in this case also highlighted and acknowledged that an employer has a business to run and it needs the company would need employees who can contribute and work effectively and efficiently. As such, it is always the prerogative of the company to assess and judge the performance of the employee in order to determine whether or not the employee is a good fit for the company. The last case I would like to share with all of you is the case of Zakia Hanum Kamis, where the court also held that the company had carried out the procedure fairly and decided that the employee has failed to improve her performance and therefore the termination was fair. I think the important thing to point out here is that the employee acknowledged or the employee had knowledge of the fact that the company was not happy about her performance. She knew all along that the company had found her performance below expectation. The employee was also warned and placed under PIP, but still failed to meet the target set by the company. From all the cases that I've shared with you, I'm sure that you can see a pattern of what the court expects to see or what the company has to prove in the industrial court in relation to managing or termination due to poor performance. It is the duty of the company to show that the work complained of was not performed by the employee, notwithstanding or despite warnings and trainings given to the employee. Also, as I mentioned earlier, the performance of an employee must be gauged against an objective standard. So always remember to set reasonable expectations and goals. This would also bring to show that the company has always been acting in good faith as well as in the best interests of the company. And one last thing to point out, reasons and comments should always be stated in the performance assessment to inform the employee why the company is of the view that the performance is unsatisfactory. It is also always important to avoid comments or phrases like no comment or neutral, as this would be dangerous in the event it is interpreted in two ways or various ways. With that, I'm done with my session and I'll hand it over back to Jasmine for our Q&A session. Over to you, Jasmine.
Thank you so much, Janessa. And thank you to Suen as well for sharing with us. We will now take the questions that some of you have already posted on Slido. I shall now bring up Slido's page. Right, the first question that we have here, the duration chance to improve. Should the senior staff be given a longer duration to improve compared to a fresh employee or vice versa? Suen, can you share with us?
Thanks, Jess. So on this question, whether a senior staff should be given longer duration, I think it really depends on what performance issue we're talking about. Because, for example, if let's say the performance issue had to do with a senior staff's lack of technological skills and you give that person only 1 month to improve, it might not be seen fair because it might take a person a while to get used to certain technology issues. Or like, for example, if it's to get used to a totally new system or accounting system altogether, it might not be fair to like just say, oh, just because you're a senior staff, I'm giving you 1 month to improve. So there are certain circumstances, and you would have to take a look at what kind of issue you would want that staff to improve. Jen, do you have anything to add?
Yeah, okay. And on top of that, generally a senior staff, if we're talking about the usual job scope where, for example, a department has a senior staff and a junior staff. So if the senior staff is performing poorly, I believe that the senior staff can be given a shorter duration to improve as compared to a junior employee. But contrary to what Suen said, I'm referring to a more general job scope where it is part and parcel of their daily work. Yep, that's all I have to add.
And the next question we have, Janessa, what if a confirmed employee of several years being transferred to another role or department, is that employee considered under a probation?
Okay, so whether or not an employee is under a probationary period would depend heavily on his or her employment contract. So if his or her employment contract states that she's under probation for 3 months, and by conduct or in writing, the company has confirmed the probationary period, confirmed the employee from probationer to a confirmed staff, then whether or not there is a transfer or there is a change in a role would not change the fact that the employee has been confirmed. Unless, of course, when the employee is transferred or when there is a change in role, there is a new employment contract, or there is a letter of consent signed by the employee to say that the employee is being placed under probation again. Thanks, Jasmine.
Thanks, Janessa. Suen, I'm directing this question to you. If I'm put on PIP, wouldn't that make me look like a bad employee?
Thanks, Jess. So just generally speaking, while there are some bad connotation to being placed on the PIP, but I think an employee, if you're performing well, you should take it as it is, just that you can show that you're performing. It doesn't make you look bad, because there are, like, how to say, what your company's allegation against you, but you would have to show by your performance that you have been performing, that the allegation against you are not right, and that you have shown significant, like, if let's say there are issues, then you can take it as an opportunity to improve. But I don't think that employees should take this to mean that, oh, their employer is putting them in bad light, that they're performing badly.
Thanks, Suen. Janessa, I think the next question is related to the earlier question as well, but here it is. If the employee can prove that they are improving, but the employer still want to terminate, what should the employee do?
Okay, so similar for both employer and employee. In the event an employee is placed under a performance improvement plan, like I said earlier, proper documentation is very important. So if you're an employee and your employer places you under a PIP, you should get a copy of all the documents as well. And if it is properly reflected in the documents that your performance has been improving throughout the duration that has been set by the company, and if you're of the view that you have been terminated unfairly, you still have the right to lodge a complaint in the Industrial Relations Department. And if the matter is referred to the Industrial Court, all these documents can be tendered in court to support your case, to say that you've been improving, but the company nevertheless decided to terminate your employment. And that itself would amount to an unfair dismissal.
Thank you, Jen. Suen, what if a probationer claims that the documentations were biased?
Okay, so previously in my slides, the court has said that they leave it to the employers. But what if the employer is now claiming that the documentation is biased, whether it's not a probationer or a permanent employee? If you think that what they said is biased, then you would have to show some kind of like proof to say that it was biased. Maybe you can show that it was that specific thing was targeted at you. If you can show that kind of proof, then I believe that the court will have a look at your circumstances and might agree with you. Jen, do you have anything to add?
And I think to add to that, to say that a company's document is biased, I think that's a very strong allegation, and it is a very subjective matter. Since it is a very subjective matter, it is very difficult for us to ascertain whether or not it is biased. But yes, like what Suen pointed out earlier, if there is a clear element of victimization or you've been treated unfairly, and if you have documents or any form of evidence whatsoever to support that statement, then yes, you may stand a chance in the industrial court. But other than that, the company has every right to place an employee under a PIP. Yep.
Okay, moving on to the next question. Janessa, can the employee resign during a PIP?
Yes, of course. An employee can tender their resignation anytime during the employment, be it a PIP or not. But if you're saying that an employee wants to tender her resignation because she or he was placed under a PIP, then I think my next question would be, are you referring to a constructive dismissal? So a constructive dismissal would be a situation where the employee feels that she or he has been compelled to do certain things or forced by the company or left with no choice because of, for example, victimization, and that's why they want to tender the resignation during the PIP. Then yes, but your resignation letter must contain the necessary statement or information to say that you've been constructively dismissed.
Okay, Suen, can monthly sales report of the employee be the valid proof of poor performance?
Thanks, Jess. First, I think you need to consider, for sales-wise, what is the target that that person is supposed to achieve. You can't just arbitrarily give that person a target and then just say, oh, you're not performing this month. That's proof of your poor performance. I think that if you are to say that a person is performing poorly based on sales report, you should at least give that person even like a sales target and whatnot. But if there is like a fixed sales target and whatnot, then a monthly sales report can be used as evidence to show whether that person has achieved that sales target.
And on top of whatever Suen has said, if the employee's employment contract or there is an internal circulation or it has been made known to the employee that the employee is expected to achieve certain targets, but the employee fails to do so, then I think that's conclusive evidence that the employee is performing poorly.
Right, and looks like we have our final question here. Can I terminate a probationer for poor performance, Jen?
So yes, you can, provided the procedure is carried out fairly, warning, notices, training, PIP, all those are exhausted, then yes, you can proceed to terminate if the employee still performs poorly.
Okay, we have one new question here. Can the employer demote or change the roles or transfer the employee to another department if the employee still doesn't improve after the PIP? Jen?
Okay, I think demotion is a very sensitive issue, and by demoting an employee, the company has to have very, very strong reason, and demotion is usually a punishment for misconduct, not poor performance. Okay, so if you simply demote an employee, the employee may lodge a complaint on the basis of constructive dismissal. That's number one. In terms of change of roles may amount to a constructive dismissal as well if it is totally different from the employee's employment contract. So no, you shouldn't change the role without any valid reason, unless of course the employee consents in writing. Transferring the employee to another department, if the employee fails to improve after the PIP, that is an option that the company may explore. But of course, it ties back to change of roles. You just have to make sure that the role of the employee doesn't change. And by transferring to another department, for example, it ensures that the employee would receive the necessary additional training, or there is a senior for the employee to turn to. That can that can play a part as training the employee or the company acting in good faith to provide the employee with alternatives. That's one way to look at it as well. I hope I answered the question.
Thank you, Jan. Well, it looks like that concludes the end of our Q&A session. For the rest of you, please join us again for our upcoming talks. We have our next talk on the 21st of October by our associates, Tommy Wong and Felicia Tang. They'll be speaking on reporting institutions and reporting obligations under the Anti-Money Laundering, Anti-Terrorism, Financing and Proceeds of Unlawful Activities Act 2001. This act is commonly known as AMLA. You can also fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in our chat group. We appreciate your comments so that we can continue to improve our MWKA online talks series for you in the future. Please do also follow and like our social accounts. And lastly, if you would like to speak to any of our lawyers, we offer a complimentary 30-minute consultation over the phone or over video conference. You can fill in the form on our website, and the link is also posted in the chat. And to our guests, thank you for joining us today. Thank you, everybody. We hope that you have found today's session informative and useful. Hope to see you at our next talk. In the meantime, stay safe and have a great day.
Thank you, everyone.
Thank you. Bye-bye.